How does Medicaid treat jointly owned assets? Have you ever wondered how Medicaid views jointly owned assets when it comes to eligibility for long-term care benefits? This is a crucial topic for many families navigating the complexities of Medicaid planning. Let's break it down. When assessing eligibility, Medicaid generally counts jointly owned assets in full. This means if you have a bank account or brokerage account with someone else, Medicaid assumes you own all the money in that account. If your name is on the account, the entire balance is considered your asset. However, if the other owner can prove they contributed funds to that account, Medicaid may exclude that portion from your assets. Without such proof, you must spend down the total amount to qualify for Medicaid. Now, let's talk about real estate. The treatment of jointly owned property, like a home or farmland, can vary. For married couples, all property is typically seen as jointly owned, regardless of whose name is on the deed. This means the spouse not applying for Medicaid can keep a certain amount of the couple's assets to avoid financial hardship. For unmarried applicants, the rules get a bit trickier. If the property is held as joint tenants with rights of survivorship, it may be protected in some situations. However, if it is held as tenants in common, Medicaid usually counts it fully as an asset of the applicant. These rules can differ from state to state, so it is essential to consult local regulations. Another important aspect is the look-back period, which is typically 5 years before the application date. Medicaid uses this period to check for any asset transfers or gifts made to qualify for benefits. If funds from a joint account were given away during this time, Medicaid might impose penalties or deny eligibility. It is vital for the non-applicant joint owner to keep clear records of their contributions to avoid any misunderstandings. In the context of Medicaid spend-down and resource assessment, jointly owned assets can significantly affect eligibility. Since Medicaid counts these assets aggressively, careful planning is essential. Strategies may include documenting contributions to joint accounts or restructuring ownership of property. Legal tools like trusts can also help protect assets. Consulting an elder law attorney is crucial to navigate these complex rules. They can provide guidance on how to manage jointly owned assets while complying with Medicaid requirements. Remember, Medicaid treats jointly owned assets as fully available unless there is clear evidence to show otherwise. Proper planning and legal advice can make a significant difference in managing your resources and ensuring eligibility for Medicaid benefits.